and Chief Magistrate Court. You also shared a newspaper article and a human resources manual that you prepared. I did take note that the submissions from the Chief Magistrate Court are dated 9th July 2021 at a time when you are a chairperson of IPOA. So I just needed you to clarify whether you were the author or you were allowed to practice while the same time being a chairperson at IPOA.
Thank you for that observation. As the chair of IPOA, I was not really in very active practice. That's a matter that had started when I was still in practice in 2018. But again, I don't think there's anything that specifically would prohibit me from doing that because I was not getting non-practice allowance. We were never paid non-practice allowance. It's an issue that was discussed at length.
Okay, I just needed to confirm whether you were the author, because at that time you were not, you were at IPOA. And again, the newspaper article and the human resources manual. We are not able to assess your adjudicative writing skills, especially when it comes to legal analysis. There is limited engagement with contemporary legal disputes, minimal application of legal principles. So again, you want to join the Supreme Court and you have submitted to us those two sample writings. Again, I needed to get your view on why you chose to submit those two.
The reason I chose to submit those two, I believe the writings are meant to show the capability, written skills capability of the judicial officer. And judicial officer writing capabilities, while most of the writings will probably in writing judgments, ruling, and court-related advisories. Writing skills are not only determined by writing judgments, it shows appreciation of other contemporary issues and understanding of other areas of law that may not necessarily be judicial writings. And I believe it's important that a judicial officer should be able to engage with a wide range of issues, while the main job is judicial writings, judgments, rulings. It's also important to understand other contemporary issues.
Okay, you have been making reference to that position as a judicial officer, but I'll leave it at that. But it's not a judicial officer role, it's a judge of the Supreme Court role. Though there are the submissions, you identify issue clearly, but I take note that they do not advance any new issues. So your contribution to jurisprudence, I can't really tell from what you submitted. Fair enough, I'll take you through a question that I had.
Maybe if you may allow, Chair. I think I submitted a writing on employment and labor relations matter.
Yes.
Constructive dismissal.
Which is okay. What I'm just saying is that they do not advance a new area. Constructive dismissal are issues that have been litigated before courts, so there was no growth of jurisprudence. You just restated what courts have declared over the years.
I've given that particular case a basis in the Constitution, Article 41. So my dream was it would go on to Supreme Court, and Supreme Court can have the opportunity to address the issue of, depending on the decision, on constructive dismissal. So yes, basically that's why I was anchoring it on the Constitution.
Okay, sorry for that. But you agree with me that this is not a
new area? Okay. Yes, yes.
Thank you.
Because of the nature of the case.
Okay. So according to the World Bank and the African Development Bank, secure land rights in Africa are important because they unlock economic potential, they secure rural livelihoods, and they are a driver for investment. Do you agree with that statement?
Yes.
And I know when you're preparing for this matter, you had an opportunity to go through the Dinner Management Limited versus the county government of Mombasa matter.
Yes.
Where, in essence, the decision challenged the torrent system.
And in essence, we cannot really trust documents from the government institutions. So it's not enough to just say,
I am a bona fide purchaser for value. You need to go deep to the root of title.
Yes.
So looking at that decision, whereas it's commendable because it has really brought to the fore the land question in Kenya, but some critics argue that it created uncertainty because the Supreme Court, the decision failed to define the scope of the due diligence expected for purchasers, investors, and developers, potentially exposing land transactions to abuse and endless litigation. I don't know whether you agree with that statement or not.
Not entirely.
Not entirely. Okay. And again, the critics also argue that the cost of institutional failures is then passed to innocent purchasers, hence weakening the constitutional guarantees of secure property rights. So this is a decision that has far-reaching consequences in the land sector in Kenya. So how should the Supreme Court balance the, and would it be necessary for the Supreme Court to develop guidelines to clarify the doctrine of root of title so that we know how far should one go, how wide should one go, and whether the credibility of that village drunkard should be considered, and at the same time hold state agencies accountable for their records?
The first question is on Supreme Court. What Supreme Court, how the Supreme Court can ensure sanctity of title. Looking at that decision and looking at the background of land law, under the common law, it was a requirement that you should look at the background of the title. The Torrens principles only came in to try and simplify the process of registration and present the title as a shield. I don't think the Supreme Court would have a problem in making decisions that touch on those aspects, because what is illegal cannot be validated by passing it to an innocent buyer. An illegality is an illegality. And therefore, if a title is acquired through illegality or fraud, it's a bad title. And that, I think, was the underlying principle in Dina and Torino. You cannot pass that which you do not have. And I think in law there is also the general principle of caveat emptor, buyer beware. I don't think the law has changed that. It's important that buyer beware what you're buying, bearing in mind you cannot pass that which you do not have. So I think that decision brings clarity to many things. First of all, how to handle public land. Public land is not meant for private use. It should be protected. If land is meant for road, reserve, public utility, it should be protected. I don't think Supreme Court would be conflicted in any way in making that determination. And therefore, it protects public land from, in quotes, being grabbed. It clarifies the law that if a title, the origin of the title is illegal. I mean, title in itself is not a final shield. The title cannot shield that which is illegal.
Okay, maybe
So I think the Supreme Court, I don't think would have a problem in making those determinations. However, in terms of the tolerance principles and the sanctity of title, I think the agencies that are responsible for ensuring what is in the registry is accurate should be held to account. There should be accountability. And probably mechanisms for compensating people who suffer, having relied on the information that is held by the agencies that are deemed to have the correct information.
If I could maybe just take you back in terms of the after effect of the decision. Critics say it has created commercial uncertainty and reduced the confidence in land market within our country. So people are not buying land. Investors are scared of investing in Kenya when it comes to issues around land, because they do not know how far they should go when you're told, go to the root of title. So is it necessary then for the Supreme Court to have developed guidelines on how far, or we just leave it at that? Or should it be on a case-to-case basis? Just your thoughts on it.
My thoughts on it is that probably this is a matter that should go to NCAJ, and involving NCAJ brings together. I had the opportunity to sit as a council member of NCAJ when I was representing my institution. NCAJ develops a high-level policy, and all critical stakeholders sit in as members of NCAJ. It's probably an area we should ask NCAJ to look at using the technical capability